Okay, good morning everybody. Welcome to the latest post-Brexit clinic that we're holding here at Queen's University in Belfast. I'm David Phinnemore and I'm with my colleagues here to talk you through a number of issues that we want to discuss today. We're going to be looking at a variety of issues to do with the implementation of the Windsor Framework. We're going to be looking at how goods are moving. We're going to be looking at some of the rights dimensions which have been featuring in the news recently. Katy's going to introduce some of the key findings from the latest polling that we've been doing, and I'm going to talk a little bit about the democratic consent vote which is coming up later this year. Before we move on to the goods, just a little refresher of what's been happening over the last 6, 8, 12 months or so. A lot has been happening on the Windsor Framework, the protocol. It started the year with safeguarding the union, which was significant for us locally because obviously that led to the DUP agreeing to go back into the executive. We had the restoration of the assembly. One of the consequences of that was, as you see bottom left, is we've now got a Windsor Framework Democratic Scrutiny Committee operating in the Assembly, monitoring what's happening with the protocol, particularly around regulatory alignment. There's also been further moves to implement the protocol. Some of those, however, have been delayed. So, as Billy will pick up later, we've had some delays to the introduction of some customs processes for parcels. We've also had a bit of a rowback on the part of the UK government from the labelling commitment not for EU labelling, and a review undertaken there. What we've also had is, quite importantly, a new government being established in the UK. Labour came to power, and I think that's brought a new tone to UK-EU relations, and also in particularly implementation of the protocol. As you see there, we've picked out a few words from Hilary Benn, who's indicated that this government is absolutely committed to fully implementing the Windsor Framework pragmatically and in good faith. Okay, I think symbolically, well, important very much because it sets the tone for the UK-EU relationship, and I think what we're seeing with the protocol Windsor Framework now is its implementation within the framework of a much better UK-EU relationship, and the UK wanting to deepen its relationship with the EU. Okay. What we also need to note with that, though, is the EU side is saying, look, okay, we're happy to follow through on this reset of the UK-EU relationship. We're happy to talk about closer relationships, but our bottom line is you've got to implement existing commitments, which includes the Windsor Framework. Okay, so Windsor Framework is being implemented. We're seeing the institutions up and running or continuing to run fairly frequently. So, for example, the Specialised Committee met recently. What we've also seen, as Lisa will talk a little bit more, is a number of court cases or court rulings recently which have been clarifying or bringing some degree of clarity to how we should understand the implications of the Windsor Framework in the UK. Final point I'd flag there is the bottom right, which was the announcement last week by the Secretary of State for Northern Ireland that the democratic consent process is being launched. This is the opportunity later this year for MLAs instalment to decide whether they want to see the continuation of core elements of the protocol, mainly to do with the movement of goods, and we'll talk a little bit more about that later. But I think we'll switch to movement of goods now, and I'll hand over to Billy.
Hello, everyone. So I was asked to give you a brief overview on the implementation of the trade elements of the Windsor Framework. And as I was preparing for this presentation, I stumbled upon some slides which I presented just over a year ago, giving some of my preliminary observations on the Windsor Framework. And I thought I'd just go over some of my concluding remarks, just to give you some background and some context to the Windsor Framework as far as trade is concerned. So in that presentation, I made 3 points where I was speculating about potential challenges and issues that might come up. The first one was just a very broad observation that one of the features of the Windsor Framework as far as the trade elements are concerned is that it tried to solve all problems, current problems then, by potentially creating new ones, right? So one example of this was that the main aim of the Windsor Framework was to address criticisms leveled at the Irish Sea border, those border checks, and one of the things that the Windsor Framework did was that it reduced the regulatory burden placed on GB goods, SPS goods, so agri-food imports from GB into Northern Ireland. But that meant that all of a sudden here in Northern Ireland, we had a separate category of goods which could not make their way onto the Republic, onto the single market. So by trying to address the Irish Sea border, we potentially created a regulatory border within the island of Ireland. The other issue is that the Windsor Framework tried to alleviate the complexity and burdens placed on businesses, and another piece of speculation on my part was that that burden, the alleviation of that burden, that complexity didn't just disappear into thin air. It was essentially displaced. It was transferred away from businesses and towards public authorities, which were now responsible for implementing this very complex system, which was intended to safeguard the integrity of the single market, to ensure that all these GB goods did not make their way onto the Republic. Okay? The other point I made was that the Windsor Framework was the start of something. It was not the end of the road. And this is true in a number of respects. First of all, because the Windsor Framework required implementation. There were a number of milestones, deadlines, which the UK had to comply with in terms of putting in place this, these raft of regulatory reforms and institutional and supervisory processes that were there to protect the integrity of the single market. And to an extent, the success of the Windsor Framework would depend on the ability of the UK to convince the EU that it had correctly applied and implemented these systems. And it was not the end of the road in the sense that the Windsor Framework was primarily focused on the Irish Sea border in reducing the checks placed on GB goods moved into Northern Ireland. But there were other trade issues, other criticisms leveled at the protocol from a trade perspective, which were not addressed in the Windsor Framework. So just to give you a few examples, there was Article 10 of the protocol, which is still in place. The criticism there was that it applied EU state aid law in Northern Ireland and arguably in the UK. There were questions concerning Northern Ireland's status within the EU trade remedies regime. There were questions surrounding Northern Ireland's ability, or the ability of businesses in Northern Ireland to benefit from post-Brexit UK FTAs. None of these issues were addressed fully. Some of them weren't addressed at all in the Windsor Framework, right? So there was a possibility there that as the discontent surrounding the border checks in the Irish Sea border disappeared, more attention would be drawn to these issues, okay? And the last point I made was that if the Windsor Framework turned out not to be enough in terms of addressing the discontent concerning Northern Ireland's post-Brexit trade regime, what would happen next? And my point was that the approach followed in the Windsor Framework, which is to dilute some of the commitments made in the original protocol, that was not an approach that could be repeated, and that future solutions had to look at the broader EU-UK trade relationship. So I go over all these remarks, first of all, to give you some context so they can remember what the Windsor Framework was all about from the trade perspective, but most importantly, it was so that everyone here in this room knows, including my colleagues, that I got my predictions spot on. I absolutely nailed them. So I'll give you a few examples. With respect to the idea that the Windsor Framework was about solving all problems by creating new ones, a good example of this is what's happened, and David, you've already mentioned, with the EU labeling scheme, right? So the idea here is that GB goods moving into Northern Ireland wouldn't have to fully comply with EU legislation, right? But you need to protect the integrity of the single market. You can't have these GB goods which don't comply with EU law make their way onto the internal market. And so one of the things that UK has to do is to have this not for the EU label placed on these goods, right? And everyone here lives in Northern Ireland. You'll have gone to the supermarket and you'll have seen those labels, okay? But that creates certain problems, and we've seen those problems play out recently, right? One of them is that GB businesses are not too happy about the idea that they need to change the production process in order to cater for this Northern Ireland market. And these criticisms were expressed to the UK government, the Conservative government back then, and the Conservative government said, well, okay, what we'll do is we'll make sure that the EU labeling requirement is implemented on a national basis, right? So that there's no differentiation between Northern Ireland and the rest of the UK. After that consultation process was initiated, businesses expressed their displeasure at the system because it created additional costs for them. So we have a new government now, and based on this consultation, they said, well, actually, we're not going to enact any legislation which applies this labeling mechanism on a national basis. We're going to stick with the Windsor framework and apply it only in Northern Ireland. Okay? But we'll monitor GB Northern Ireland trade, and if anything happens, if there's any evidence that GB businesses are no longer supplying to Northern Ireland because of these labeling mechanisms, we'll revisit this policy stance. So here you have an example of a reform which was intended to alleviate or reduce the regulatory burden on GB business goods moving into Northern Ireland, but actually we've ended up creating a regulatory border within the island of Ireland, whilst also creating additional barriers to trade in the form of these labeling mechanisms, these labeling requirements. Okay, so there are a lot of unintended consequences which came with the Windsor framework reforms. An example of, if I can see my slide, of the Windsor framework not being the end of the road. And here, again, David, you mentioned this. We had this requirement, well, Windsor framework envisage new customs facilitations for business-to-business pass movements from GB into Northern Ireland. This was supposed to be implemented by October this year. The UK government was not able to implement these new processes on time because of the election. And the new government thought that it would be best to postpone the implementation because we were entering the Christmas period and it would be too disruptive. So now there's an agreement from both the EU and the UK that this will be put in place. I think it's end of March next year. Okay. Another example of the Windsor framework not being the end of the road is what's happened with the EU's decision to apply countervailing measures. So countervailing measures are high tariffs which apply on goods which are considered to be receiving unlawful, illegal subsidization, so illegal under WTO law. In this case, it is targeting electric vehicles from China. Under the protocol and under the Windsor framework, the same. Those high tariffs, the UK has to apply those high tariffs on any goods coming into Northern Ireland, including electric vehicles from GB into Northern Ireland, as long as they're being targeted by those tariffs, so they're of Chinese origin. Okay? So you see here this headline from the Telegraph. So the European Union is dividing the UK with an electric car border, but this is just a natural consequence of the application of the protocol as it was agreed by both parties, right? So these are problems that remain in place and were not addressed by the Windsor framework. The last point, and I'm sure I've run out of time by now, which was the argument I made about the approach of trying to resolve issues created by Northern Ireland's post-Brexit regime by diluting the commitments and the obligations in the original protocol, and how that had potentially reached its limits. Well, the interesting development here, and David, you've also mentioned this, is that the new government has proved to be more receptive to a reset in the EU-UK trade relationship, and one of the things it's mentioned is that it's receptive to negotiating a veterinary agreement with the EU. Now, depending on the level of ambition of this veterinary agreement, it could solve a lot of the problems we've been discussing so far, specifically with respect to border checks on SPS goods that are moving from GB into Northern Ireland. So if we're talking about a Swiss-style agreement, which would require full-on dynamic regulatory alignment, that would pretty much remove all these checks, right? But there are different types of mutual recognition agreements, different types of veterinary agreements. So it all depends on the extent to which the UK is willing to relinquish some of its regulatory autonomy in this field. Okay? So far, it's been a mixed bag. It's been quite negative in terms of what I've explained to you. So I'll end on a positive note, which all of these issues have popped up, and yet we've barely heard about them, and both the EU and the UK have tried to resolve them behind closed doors, right? So the example of the parcels, the business-to-business, there was an agreement on both the EU and the UK to just postpone it. All of this went without any controversy or fanfare, and that, I think, is possibly the most positive effect of the Windsor Framework is that it placed both the UK in problem-solving mode. There seems to be a recognition on both sides that the protocol or the Windsor Framework or whatever we want to call this Northern Ireland post-Brexit trade regime is one that's dynamic, it's fluid, issues are going to come up over and over again. And so both parties have to be willing to address those problems on a day-to-day basis. So I'll leave it there.
Okay, thanks very much, Billy. I'm sure there'll be some questions on that, but I think if we can hold our questions to the end. For those of you who are online, if you've got questions, do put them in the chat and we will come back to them at the end. Okay, we've had some discussion there of goods. Lisa, over to you on Article 2.
Yes, thank you, David. I am going to speak about a provision of the Protocol Windsor Framework that at least rewind back a good few months, and it wasn't discussed as much as those elements that Billy's just set out for us. It concerns the rights of individuals. Also, in advance, forgive me for really looking at my notes for those in the room, because I have absolutely no chance of sticking to 5 minutes if I just riff on this, because it's very interesting. So, Article 2 of the Windsor Framework concerns the rights of individuals. As indicated there, it introduced a UK government commitment to ensure no diminution of rights, safeguards and equality of opportunity, as set out in a relevant section of the 1998 Belfast Good Friday Agreement, and that no diminution should result from the UK's decision to withdraw from the EU. While the Protocol Windsor Framework in general is a novel legal text and set of arrangements, this provision is arguably even more legally innovative than the others, in so much as this is a UK government commitment in an EU-UK treaty that is directly linked to a bilateral international agreement between the UK and Ireland signed over 25 years ago. Why does that matter? Well, it suggests that the exact parameters of what this provision would or could mean was always likely to come out in the courts. And hey presto, that's kind of where we are. So early on, the UK government characterised Article 2 and its commitments as not controversial, particularly compared to the trade elements and implications of the Windsor Framework. It's a bit disconcerting. But fast forward some years and some domestic legislative initiatives, and this UK government perspective on the lack of controversy surrounding Article 2 probably started to change as challenges were being brought against the government and the legislation that it had enacted or planned to enact on the basis of certain provisions within that new legislation being in breach of Article 2 and the obligations it creates for the UK government. Perhaps most prominently, the Illegal Migration Act was found to be in breach of Article 2 of the Windsor Framework, as well as the European Convention on Human Rights by the Northern Ireland High Court in a case brought by the Northern Ireland Human Rights Commission on behalf of an asylum seeker located in Northern Ireland. When the Labour government came in to power, it amended the Illegal Migration Act such that the remedies that were introduced by the Northern Ireland High Court ruling for its implementation here regarding disapplication of those aspects of the Act that were deemed in breach of Article 2 sort of became less significant, no longer applicable. But this wasn't the only Article 2 case. The Northern Ireland Troubles, Legacy and Reconciliation Act 2023, generally referred to as the Legacy Act, had also been challenged in the Northern Ireland courts on the grounds that it breached Article 2 of the Windsor Framework obligations due to its provisions for an effective amnesty for perpetrators of atrocities committed during the Northern Ireland conflict. In February 2024, the Northern Ireland High Court ruled against the previous Conservative government to say that aspects of the Legacy Act breached human rights law obligations, including those laid down in the Windsor Framework, Article 2. The UK government then appealed that decision. Again, initially, that appeal was brought by the previous administration. And when the Labour government came into office, although they had committed to repealing at least the most controversial aspect of the Legacy Act, it also, as in very small font, the slide indicates, my apologies, it committed to continuing the appeal started by the previous government, in particular against those aspects, the grounds of the appeal that focused on Article 2 of the Windsor Framework. The premise of the new Labour government doing so was that the court's position, the Northern Ireland High Court position, in the previous ruling on the Legacy Act, in regards to the interpretation and effect of Article 2, raises, in their words, profound constitutional and legal questions. And the Labour government characterised the necessity of continuing the appeal as to bring further clarification on a technical point of law. We can discuss that further, but this brings us to the case in question, which is Dillon and others versus the Secretary of State for Northern Ireland. The substance of this case was rightly identified to be wide-ranging and engaging many complicated issues by the court across domestic law, EU law and international law, and the interaction between the three. Nonetheless, the court distilled the issues into 6 essential questions outlined on the slide, 3 core and 3 ancillary. For our purposes, the first one is most important because it addresses the issue mentioned at the very start regarding the exact parameters of what this legally innovative novel arrangement of Article 2 of the Windsor Framework actually means and its implications for the development of law in the UK going forward. The UK government appeal in the case of Dillon proposed that the judge in the High Court in the previous ruling had been mistaken to rule that the Legacy Act was incompatible with the Windsor Framework and therefore had further been wrong to rule that relevant aspects of the Legacy Act ought to be were disapplied as a consequence of their incompatibility with Article 2. As the court in the Court of Appeal ruling described, the multifaceted grounds of the UK government's approach on this issue amounted to a frontal attack on Article 2 and the way in which it had been interpreted up until this point. The key question, and this is how the court distilled it down, we'll not get into all the details, but that first highlighted one, can Article 2 be relied on? The underlying concept or issue at play here is the direct effect of Article 2 and those EU laws that it brings into scope and applies in domestic law, so whether or not Article 2 has direct effect in the UK legal system going forward is the question. The court answered, in the case of Dillon, that question definitively in the affirmative. Article 2 of the Windsor Framework, in their words, is directly effective. Moreover, that the provision speaks for itself, and in their view, it is ideally adapted to produce direct effects in the relationship between the state and the citizens mediated by law. And the concept of direct effect essentially is that individuals and legal persons can rely on this provision to be the law and therefore can take challenges on that basis if it isn't being upheld. So has this ruling recently conclusively resolved all of the grey, ambiguous issues around this Article 2 provision? No, certainly not. The court ruling, according to recent announcements, is set to be repealed by the UK government in the UK Supreme Court. We haven't, at least as far as I'm aware, received notice of the specific grounds or the detailed grounds on which the UK government will appeal. And they will be worth reading when they do come forward. But there is a wider issue here, I think, about the outworking of Protocol Windsor Framework related issues, controversial or otherwise, under the new Labour administration that began under the previous Conservative administration. So it's how that legacy, if you will, is being dealt with and handled and managed going forward by this new UK government. And on that broad issue, Article 2 is going to continue to be one to watch. That's me.
It is one to watch, I think, as with so many other different features of the protocol. As you know, as part of the project we've been running, we've been testing public opinion on different protocol Windsor Framework aspects. We got the data from our latest poll last week. We're publishing the findings on Thursday, but Katy's going to give you a sneak preview of some of those findings this time round. Katy.
Thanks very much, David. Hi, everybody. Many thanks to Bill White and Lucid Talk for being great partners with us in these regular polls. So as David says, this is the 12th. So this means most of you have sat through 12 or 13, actually, of such briefings. So congratulations. The response rate has maintained at a fairly high level. So with this one, it was 2,700 or so, and then the weighted sample is 1,020 with a margin of error of 2.3%. I've tried to use the green lines here and the blue lines. It's a slightly subtle way, but I hope that sort of shows you where things stood back in June in the previous poll compared to now. And what we see overall is a slight decline in the positive views about the Windsor framework, including in relation to its views of its economic impact and the opportunities that it provides for Northern Ireland. Still, though, that's the most positive view, really, in terms of the impact of the Windsor framework generally, at 63%. We also see a slight decline in those thinking that particular arrangements are necessary for Northern Ireland, that the Windsor framework provides appropriate means of managing Brexit, and that it's on balance a good thing for Northern Ireland. And it's notable that that idea that the Windsor framework is on balance a good thing for Northern Ireland has slipped back to where it was prior to the Safeguarding the Union deal, although it's still just 50%. Also, on the decline is the view that reliable information on the Windsor framework is available. We tested this in questions that I'll talk about at the end to see, dig into this a wee bit more. But despite that, people remain confident that they have a good understanding of the protocol. This is that time series chart that we've been showing for a while now, that we can see how things have changed since our first poll in spring 21 to where they are now. So you see the difference that was made by the Windsor framework happening, and still things are better than they were before that. But as I say, you can see the slight drop since that there's been over the last year and a half or so. Even though we do see a big gap, relatively speaking, between those who think it's on balance good compared to those who think it's on balance a bad thing, there isn't a strong direction towards a positive view of the Protocol Windsor framework. And then the specific questions on the impact that the Protocol Windsor framework has. There hasn't been major movements on any of these, so I think possibly what's most striking perhaps is the consistency that we've had over the last few polls. Noting, of course, that the context for this poll was one in which, as Billy mentioned, things have been fairly low-key, not big headline-hitting stories as there were before the Safeguarding the Union deal about the Windsor framework, and yet there seems to be consistency in people's views on it. Even the question of Article 2 and the cases hasn't really affected people's views on whether the protocol ensures no diminution of rights. That's slightly dropped, but not significantly. Still, a majority think it protects the Good Friday Belfast Agreement, that it's positive for North-South cooperation. Consistently, we've seen many more negative views than positive ones on the impact of the Windsor framework on Northern Ireland's place in the UK internal market and on its constitutional place in the UK. As I mentioned before, in terms of the economy, that's where we see the most positive views about its impact. And there has been a significant change over time post Safeguarding the Union deal on the views on the impact of the Windsor framework on political stability. And this is quite obvious, I think, because we've still managed to keep the Assembly functioning for the time being. One thing that we note is that the difference between those thinking that it has a positive impact on political stability and a negative impact is smaller than it's been before. Pre-Windsor framework, it was far more negative views about its impact on political stability, whereas now there's only a 4% difference. much more positive views on British-Irish relations as being affected by the Windsor Framework, and on UK-EU relations, and that picks up on the points David has made about the UK government being that much more explicit about wanting a better relationship with the EU and trying to reset that relationship. We also did, for the third poll in a row, wanted to see where issues of concern lie. This isn't clearly a comprehensive list. It is just trying to see where things lie in relation to each other and issues of concern amongst citizens and voters. We haven't seen major change, major movement in any of this. Very slight decline in those putting the effects of the Windsor Framework in the top 3 issues of concern, and a slight increase from about 15 or 16% of those putting immigration in their top issues of concern, but no major change in this pattern. Now, there is some good news here for the new government. So in our last poll, I think it was 4% levels of trust in the UK government, which is up from the lowest of 2% or whatever it was. But anyway, it's up to 8% now. 8% of our respondents say they trust the UK government in managing Northern Ireland's interests in relation to the Windsor Framework, and the levels of distrust at 74% are the lowest ever, I think. So in relatively speaking, that's good news for them. We also note, even though views on political stability had improved somewhat, there's been a slight decline in levels of trust in the Northern Ireland executive, a point I'll come back to later. Slight decline in trust in the EU and Sinn Féin in relation to this, also in relation to Alliance and the UUP. So there's a little bit of movement there, but they're not far outside the margin of error to be making any fuss about. Similarly to with regards to trust in business and civic society. So I think there's maybe slight rise in distrust levels, and we see this in relation to lots of things, not just on the Windsor Framework, across not just the island of Ireland, but indeed Europe and further afield. And then, last but not least, these extra questions we asked this time round, new ones, trying to basically get a sense of whether these polls are useful or not for people, whether we should continue to do them, maybe slightly less frequently. And so, generally speaking, we see positive responses to that. So people thinking there is a value, thankfully, to work on measuring public opinion around the Windsor Framework, possibly because, as you can see there from the top question, 84% of people expect the Windsor Framework Protocol will continue to be contested in Northern Ireland politics for the foreseeable future. One other notable finding is that across the board, and this includes response of all perspectives, people would like to see joint presentation from the UK and the EU regarding factual information on the Windsor Framework Protocol. And interestingly too, even though perhaps many of us have enjoyed the slight decrease in media coverage and hype about the Windsor Framework, most people think that there needs to be more media coverage on the Windsor Framework to enable voters to be informed on its actual effects. So as David mentioned, we are publishing the report on Thursday, and we've got much more granular detail in that if you'd like to find it on the website. Thanks.
Okay, thanks very much, Katy. There's a couple of slides we've not included yet because we want to hold on to them after I've discussed democratic consent, and that is where people view or what people think MLA should be doing when we get this vote. 5 years ago, this vote seemed a long way off. It's now imminent, and we will get what is a fairly novel provision for the Assembly to vote on what is essentially a UK government agreement with the EU for that vote to take place. Okay, say a few words about the vote and what we can anticipate in the coming months. First thing to say is, although people talk about this being the democratic consent vote on the Protocol Windsor Framework, it's only on part of it. It's a big part, admittedly. It's all about the movement of goods that Billy mentioned. But I think equally it's important to note that there are certain aspects of the Windsor framework which are not covered by the vote. For example, Article 2, as Lisa was discussing earlier. And so if the Assembly were to vote down democratic consent, this would not be the end of the protocol, Windsor framework. Certain elements would continue. Okay. The second thing is we're not exactly too sure how it's going to plan out in the forthcoming weeks. As I said earlier, Secretary of State laid or triggered the process last week. It's now up to the First Minister, Deputy First Minister to decide whether they want to lay a motion for debate within the Assembly. They've got until the end of this month to do so. If they don't lay a motion, it's then down to any MLA to lay the motion themselves. They don't have to. I think in all likelihood there will be an MLA who will lay it, and so there would be a vote. That's what we're expecting. We then have a deadline of 17th of December, essentially, to have the vote. And we will know what we'll get the result then. And then there's formal notification that goes to the EU from the Secretary of State indicating the outcome of this process. Okay, if there is a vote, and I think we're almost certain to see a vote, what can we expect the outcome to be? Well, based on what we understand of the party political positions and their public statements to date, we anticipate that potentially 53 of the MLAs will vote in favour of democratic consent, which is 59%, and at probably 27 of the MLAs at least will vote against. Essentially, these divide along the lines of nationalists and others voting in favour, and unionists voting against or possibly not voting. And that's what we anticipate. So what we'll probably get is a simple majority in favour of continued application. That's significant because it's not cross-community consent. And as I'll show in a moment, it matters for when the Assembly comes back to vote on this a further time. Okay. So that result, if it is in line with what we've indicated, would map onto what public opinion is telling us about how voters would want MLAs to vote. This is one of the questions which we've asked throughout the polling. And as Katy indicated, Windsor framework on this and other issues is important. We had a fairly narrow 10 percentage point gap for much of 21, 22 in views on this. But since Windsor framework, that gap has opened up, and there's been a fairly consistent majority of voters wanting MLAs to vote in favour. That said, there's a strong third there which is opposed to the continued application of the protocol. This really maps onto some of the findings we've seen earlier about people's attitudes towards the protocol, whether it's a good or bad thing. As you can probably appreciate, given what's been said already and what we know about the politics of Northern Ireland, most of the people here who are arguing in favour of MLAs voting in favour would be from a nationalist or other background, whereas the view amongst particularly strong unionists is very much opposed to the Assembly voting in favour. Okay, so not much change there in terms of our polling data this time round. I said earlier that the outcome of the vote matters in terms of whether it's a simple majority or cross-community consent. Assuming there is a majority in favour, we take the green route here, and that means that after 4 years, we have the opportunity to vote, MLAs to vote again on the continued application of the protocol. Okay, so this is not the last vote if the vote is in favour of continuation. Other votes will be possible in due course. Before that vote, which would take place in 2028, we'd have an Assembly election, which raises the question how important the issue would be at that particular point in time. And there'd also be the optional public consultation, but you then come back again. If there were this time round, however, cross-community consent, which seems extremely unlikely, there'd be 8 years until the vote would be offered again. If there is no consent, which is obviously a possibility, then we have a situation where after 2 years, the provisions in Articles 5 to 10 of the Protocol Windsor Framework, those governing movement of goods, but also the single electricity market, would essentially cease to apply. They would halt, their application would halt. That then begs the question, what would replace them? And the default is the terms of the UK-EU Trade and Cooperation Agreement, which put simply means that if we were to have no consent and if there were no alternative arrangements put in place, Newry-Dundalk would be the same as Dover-Calais in terms of the movement of goods. Okay. Now, there is a commitment, if there is no consent, for the UK and the EU to try and find other arrangements and take necessary measures. But there's no guarantee that those would necessarily produce anything novel, new, either, certainly compared to what we've got already. So let's just focus a little bit more on the green route there. Our assumption being that there will be a simple majority in favour of consent. What that triggers is an independent review of the Windsor Framework or the operation of it. That review was originally due to report, I think, by 27 or so, but under Safeguarding the Union, it was brought forward, and essentially the Secretary of State is now required by law to appoint an independent chair of that review within a month of the democratic consent vote. Okay. That review then has to report within 6 months. So by July, it should have reported. Now, the review is potentially very wide-ranging in terms of its remit. Originally, it was there to look at the operation of the Windsor Framework, but as a consequence of Safeguarding the Union, it is now possible for it to be looking at the broader constitutional implications of the Windsor Framework for Northern Ireland. I stress, though, that there is a may provision there. It may. It is not necessarily assured that it will be given that responsibility as part of its remit. There's meant to be broad consultation as part of this process. We will see how that plays out in the new year, assuming that it is down the simple majority consent route that we go. Suffice to say, it means a lot of the issues which have been in the background, I think this time, may be coming to the fore, because this review will coincide with the introduction of the parcels regime. It could come in, it could be on the back of what could be a fairly fraught debate in the Assembly. And I think we've already seen indications, certainly from the DUP leadership, that they will see the review as an opportunity to raise their concerns about what the Protocol Windsor Framework means for Northern Ireland. So I think we're in for an interesting first 6 months of next year. We'll see how that plays out. Okay. Okay. And if you want to know more about the democratic consent vote, as you'll see on the left-hand side, we've been busy preparing a number of explainers. We've got a fact sheet there, Q&A, which is available online at the address you've got at the bottom there. And if you really want to go into more depth, then Lisa and I have, I think, produced about a 20-page, more detailed explainer of what this democratic consent vote is all about. No, anyway, happy viewing, happy reading of those if you're minded to do so. Anyway, I think that brings our 4 presentations to a close. As I said at the beginning, we're happy to take any questions you have either online or from those of you who are with us in the room. And over to you. Okay. We've got one question here.
Thanks. More than one, actually.
Okay.
Maeve Cormican. The first is about a slide, a few slides back, about the kinds of questions that were asked of people in terms of what was most important to them. Health and social care was at the top, and it kind of went down from there. Is there a reason why environmental or climate issues as a question aren't asked? Is it because they're kind of deemed irrelevant to the framework, or is it another reason? Second question is around the actual frequency, I suppose the last slide's a frequency of voting on the framework, and linking back to the fact that of all the different groups who have trust in Northern Ireland, it's actually the business community which has the highest levels of trust, and they're presumably those that are most impacted, not just by the decisions, but by the uncertainty of frequent votes, every 4 years. As you said, 5 years ago, it doesn't seem that long, but it's gone very quickly. The extent to which, I suppose, we're hearing the voice of business, not just about the outcome of votes, but how the uncertainty and of frequent voting can impact their ability to invest and make decisions. And then the third question is a bit more specific on Article, was it 8 or 9? It's a single electricity market anyway, yeah. And whether, I suppose, is there any work being done on understanding what has happened with electricity trade flows between GB and the EU to kind of impact our understanding of what could happen to electricity trade flows within the SEM, within the all-island market? You know, I suppose the level to which we understand what has happened with electricity flows. So they're very different questions. I'm not sure who to ask them to. I'll just leave them.
Okay, thanks very much. I'm going to turn straight to Katy, because there's at least 2 questions there for her.
Yeah, so on environment, we asked, I can't remember when it was, over a year ago now, we had a longer list of questions, and environment, sadly, from my personal point of view, was really low down. And when we're trying to work something about relative ranking, we needed 10. So obviously there's also, somebody raised a point, there isn't housing in this list. We wanted to make the list consistent with the way it was when we'd set it up 2 polls back, so hence the continuity there. So yeah, there's definitely not a comprehensive list on issues that maybe many of us would think should be top in terms of the capacity of the responsibility of the involved executive, because you're absolutely right, environment is important, although perhaps not as covered as much by the Windsor Framework as it should be, but we're really thinking about what the Assembly should be focusing on, political issues. Just if this isn't stepping beyond the remit of this session, in Northern Ireland Life and Time Survey, the political attitudes module that we'll be publishing sort of May, June next year, we ask a whole section on climate change and the environment, so look forward to that. And then on business, so yes, we've consistently seen them being the most highly trusted voices, and we can only speculate on why that is. We don't see comments being written by people in the comments section about that. And in the past, we have just really presumed it to be because they were the ones who were speaking out with facts, with explanations, with examples and stories about the impact of the Windsor Framework and how they're having to navigate it. And I think with that factual information and explanation and the sense that they were a trusted voice, I think that sort of just was reflected here in the sense that people trusted them more. Again, there's no, I can only speculate as to why that's dropped slightly this time. But as you can see, the trust levels have dropped across most of the field. And maybe it's because they haven't been so much in the public arena on this recently. Things have been more low-key, but I suspect it's more because there's lower levels of trust across the board in all sorts of institutions.
Okay, any colleagues want to pick up the single electricity market question?
Yeah, I did an explainer on it. It's a very good question. What I will say, I can't cite you research on the impact on electricity flows GB to EU, but I would say that to take findings on that basis and look across to see what impact would take place if the single electricity market was to stop operating, you're not comparing the same issue just because of the way in which it's set up on the island of Ireland, it being a shared market, everyone's pulling from the same place. So the impact on flows of electricity and also the regulatory complexity and questions raised about GB to EU are not the same as would be raised if you had decoupling of the two networks, north and south, because they are within that one market. So for what it's worth, I think the democratic consent mechanism process that David was setting out in the event of a vote against continuation of Articles 5 to 10, that 2-year window where there may be consideration of alternative arrangements or methods, I think single electricity market would be quite front and centre of at least some of those conversations, because to disapply the EU law, to de-link the legal frameworks that underpin that, we would have to really remake the infrastructure that we currently have. So I think that could be something that, it could be an issue that doesn't ever actually materialise because of just the practical difficulties. Is that like a non-answer answer, hypothetical answer? Thanks. Do you want to go to Meban? Go for it.
Hello? Does this work?
It will.
It does? Oh, yeah. Yeah, so, yeah, I don't know if this relates to your question, but it definitely relates to the electricity situation, which is the adoption of the CBAM, which is intended to address, carbon leakage, to ensure that countries that don't have equivalent emission trading schemes don't attract EU firms, in order so that EU firms can avoid having to, put up with a very cumbersome emission trading scheme. And the problem for Northern Ireland, of course, is that it is only aligned with the EU as far as electricity is concerned, but the CBAM covers a lot more. And so when the CBAM comes into play, because right now it's still in the implementation phases, there is a possibility that if there is no alignment in the emission trading scheme between the UK and the EU, that you have carbon levies applied between GB and Northern Ireland. Yeah.
Okay. There's any other questions in the room at the moment? We've got a couple online at the moment, and they relate to whether there's been anything happening with regard to the Stormont break and applicability motions. Said earlier that obviously with the return of the Assembly, we got the Democratic Scrutiny Committee, but we also got was the opportunity for MLAs to play a role in decisions about new pieces of legislation being added to the scope of the Protocol-Windsor framework, but also to engage in changes or in objecting to changes to existing legislation applying in Northern Ireland through the Stormont break. My understanding is we've not seen any use of the Stormont break so far this year. Doesn't necessarily mean so there won't be attempts to use it in due course. And whereas we did have 2 votes on applicability motions earlier this year, there's not been any more held since, although I know there's some legislation which the EU is seeking to see added to the protocol Windsor framework, which would be subject to the applicability motion in due course. There were, of the 2 applicability motions which were voted on earlier this year, one passed, which saw the piece of legislation being added, but there's one which was not supported, which I think was the geographical indicators for craft products. Basically, the UK has to notify the EU at some point whether it is or is not agreeing to the addition of this piece of legislation to the relevant annex. Our understanding is it's not indicated as yet what it's going to do, but at some point it will have to be addressed. We'll see how these processes are used, because I'm sure they will be, or at least there'll be efforts to use the Stormont break at some point in the future. Lisa.
It's just worth noting on that the new European Commission are still getting up and running. So if we're looking at alignment and the impact of changes in EU law and how that's being dealt with in Northern Ireland, we are in a period that is a bit of a lull for the reason of the EU's processes.
Any other questions? Yeah.
No, I want to touch on about, and probably what some Billy had said previously, is with the UK with the introduction of the new metrology and product safety and metrology bill, which will be an enabling act, or once if it's passed. Now I understand Scotland isn't too happy about it because obviously and Northern Ireland as well with transferred matters, but the fact that that would enable the Secretary of State, where it be the Department of Trade, to issue a statute of instruments effectively to mirror any, and one of the most, I think, most critical things maybe coming down the tracks is the new product safety regulation that must be effective from 1st of December, which obviously will apply to the Republic of Ireland. So really just in that there, it sort of be, there will be more, I suppose, using that piece of legislation, there will be more alignment, and it'll be done just quietly, honest. I mean, placed on the floor of Parliament, and that's it. And you know, legislation will be there, and the UK and EU will be aligned effectively.
Hello? Yep. So for that bill, I can see not just alignment in terms of EU-UK, but also alignment in terms of the Labour government's position in terms of resetting the EU-UK relationship, because of course it facilitates the process of negotiating that veterinary agreement if you can maintain that alignment at a very close level, right? The thing with the metrology bill is, and I won't speak about the devolved element, and maybe Lisa can touch on that. The thing with it is that it's not the same as mutual recognition, right? It's unilateral alignment in the sense that the UK can follow what the EU is doing, and that, of course, reduces the burden placed on businesses who will be subject to a set of rules which is the same as in the EU, so they don't have to adapt their products to sell to the EU market, so that's helpful. But unless you have mutual recognition of rules enshrined in an international treaty with a system of either regulatory equivalence or recognized dynamic alignment, we'll still face border checks and barriers to trade. So I see this bill as something that can facilitate the path towards dynamic alignment rather than something which solves the problem of those trade barriers.
CE mark or something like that there on your goods.
Yeah.
That should allow it then.
Yeah, but you can do anything unilaterally, but you still have barriers to trade because you still have to get to the border and demonstrate compliance, right? Unless you have a pre-existing recognition agreement where EU officials will say, well, we know that goods that are coming from GB or from Northern Ireland, from the UK, they're completely aligned with ours, so we don't have to worry about the quality. Right? If you do things unilaterally, that helps your businesses in terms of, okay, there's no divergence, we don't have to adapt our products, but you still have to go to the customs officials and demonstrate equivalence. Right? It'll be easier to do so, but you still have that check. I don't know if that answers the question, yeah. Yes, yeah.
Then links into the future of the UK-EU relationship.
Sorry?
That then links into the future of the UK-EU relationship.
Again, as I see it, the metrology bill is a stepping stone towards paving the way for a veterinary agreement. And if you have a veterinary agreement where the EU and UK agree to some sort of dynamic alignment, which is what you have with Switzerland, where essentially Switzerland just accepts to copy-paste EU legislation to keep pace with EU legislation, then you avoid the issues we're talking about. But as I was saying in my presentation, there are different types of veterinary agreements. For example, you have the New Zealand agreement, which is pretty good, but it's product specific, right? That reflects the fact that New Zealand is very far away, and there are very few products that are traded between New Zealand and Northern Ireland. And even then, you have documentary identity checks and physical inspection checks. But that's because it's a regulatory equivalence agreement rather than dynamic alignment. So depending on the type of sacrifices you're willing to make in terms of your regulatory autonomy, that will affect the level of barriers to trade that goods will face, right? The more aligned you are, obviously, the less autonomy you have in terms of setting your own rules, but the fewer checks there will be.
Hey. No more questions as yet. I wonder if I've got a couple of questions for my colleagues. We're sitting here, we've got a slide up at the moment which is looking at trust. I just want to know Katy's views on, does she actually think this is ever going to really change much? Because it's in a fairly consistent pattern over the time of the polling that we've been doing here, particularly the dire state of trust in the UK government. I'm just interested in her views as to whether we will see this shift over time, particularly given the fact that one of the responses to our questions in this poll was that people do expect political contestation around the protocol to continue. That's an overwhelming majority took that view.
I mean, we shouldn't lose sight of the fact that people's views as to whether they trust certain parties or institutions or authorities or not relate to their views about Brexit itself. So, if the UK government goes down the route of ultimately veterinary agreement dynamic alignment, it may gain the trust of some and lose the trust of others. And this is the challenge, of course, that we have in anything around Brexit, therefore Windsor Framework, is the fact that the very binary nature of it. And we are some way off yet seeing sort of a normalization, as this is a policy challenge, practical challenge that needs to be addressed, out with those huge questions around, Europeanness and identity, etc.
Got a question here. It's very much one for Lisa. Okay, from Claire McCann. Questions about the impact of the Retained EU Law Act. Are there ongoing risks regarding inadvertent repeal of measures within scope of the Windsor Framework and impact on legal certainty in Northern Ireland? Do you want to say a little bit about the Retained EU Law Bill and some of the issues which Claire's addressing, flagging there?
Excellent question, Claire. Thank you. So yes, the Retained EU Law Act introduced a range of changes to a status and category of law previously known as the Retained EU Law, which was the wide sweep of the legislation that was copy and pasted from the period of the UK's EU membership as EU law into domestic law on the date of the end of the transition period when EU law stopped applying in the UK. When we think about divergence issues, Retained EU law, that copy and paste exercise, made the potential cliff edge that could have resulted in terms of the legal effect of Brexit way, 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 way smaller, because it sort of set a new default, and it was from that point of effective equivalence in the legislative provisions, and from there going forward, changes would be made on the UK side and on the EU side. So in that respect, it sort of set a foundation, but we've obviously moved on from that point. And the Retained EU Law Act previously was going to remove vast sections of what was Retained EU law, but the UK government changed approach and just removed some specific pieces of Retained EU law, most of which were essentially redundant anyway. But what it did do in that act was to change the status of the copy and paste legislation from it having a higher than normal status in the UK legal system, which came with a sort of hierarchy of it being over normal law, which previously applied when we were within the EU, these general principles of EU law, including the principle of supremacy of EU law and the requirement for it to continue and be other acts to be disapplied if it was in breach of. So it removed that sort of higher status that had been copied into the UK legal system to this UK category of law, but one that was a legacy of its EU membership. Are you still with me? So the change in the Retained EU Law Act means that while legislation that did apply still applies, it's easier to change it, and it's easier for changes to be made because ministers have been newly empowered to make changes in that category of law, and to do so in a fashion that does not increase the overall regulatory burden applied on relevant stakeholders. So this act has a deregulatory preference. So you can't increase the regulatory burden through changes that you're making to this category of what is now assimilated law. Why any of this matters, or how it particularly hits in the Northern Ireland context and legal certainty here, is that if you understand the Windsor Framework applies EU law as EU law, so it still has the general principles of EU law and the supremacy of EU law, and Northern Ireland is dynamically aligned in relevant areas, so it's still following the evolution of EU law as it changed from that point at the end of the transition period where there was an equivalence across the board or between the UK and EU systems. Also, the Retained EU Law Act means that changes can be made by ministers in different parts of the UK without reporting what changes are being made to what laws when and how. So it gives a new capacity for intra-UK divergence and for intra-UK divergence to be taking place without maybe full consideration, just because of a lack of notification or understanding as to the potential implications, in particular in Northern Ireland, where we are still linked to that category of law, and as EU law it applies. So in terms of legal certainty and monitoring and tracking, because there isn't really a system or a requirement to map changes that are happening in this now assimilated law category and their effect, in particular in Northern Ireland, but more broadly within the UK internal market, it does introduce new potential for divergence within the UK, and in a manner and to an extent that there is just a lack of certainty. There's quite an inherent lack of certainty in the whole picture. The one sort of more positive, and I'll close with this and stop monologuing, point to be made is back to that UK-EU relationship and alignment, and the desire to, at this point, sort of mirror dance what's happening in elements of the EU market, means that because the intention of policymakers across the UK may not be anymore to actively move away from EU standards and regulation, it may mitigate the potential for intra-UK divergence to result as a consequence of the Retained EU Law Act. But we're still in this sort of testing period. So to Claire's question, does it increase legal certainty? Yes.
Okay, thanks. Huge complexity around so much of this. Okay, when I've got another question on the floor here.
It's actually linked to Lisa's point. I can remember listening to a debate on a particular aspect of law, and they decided, I think it was the minister decided he would just deviate without even consulting with the devolved regions, which was, really, it was quite fascinating to hear it actually said out loud, we're going to do this anyway. I think, but it struck me just from a current piece of work just around, is the oversight sufficient here when we're talking about deviation in law and what it means, particularly for Northern Ireland? Are the structures and governance and oversight in place sufficient to actually track and monitor and understand the impact of what could happen? Because what I've seen certainly would suggest it definitely isn't.
Lisa?
Personal view, I don't think there is. It's something important to note that the changes that have been brought in are so multi-leveled, and the new system that we have in a Northern Ireland perspective in particular, there's a requirement to follow what's happening at EU level, specifically in Protocol Windsor Framework applicable EU law, but also in other elements of EU law that are going to have implications on the island of Ireland because we share an island, and in areas of North-South cooperation. There's also the intra-UK element, so what's happening in other parts of the UK and how that impacts for Northern Ireland's interaction with and trade within the EU or UK market, both directions, GB to NI, NI to GB, but also the broader UK policy developments that may have a particular impact here because of the obligations under the Protocol Windsor Framework and the Island of Ireland and 1998 agreement, and in particular we're talking there about trade policy and the negotiation and conclusion of trade agreements because of how it will intersect. There is nowhere in the UK system at present that has a mandate to look at all of those elements and the other elements we haven't mentioned. So if you're sort of trying to assess, is there sufficient capacity? No one's even suggesting that they're trying to achieve sufficient capacity to look at all of the different elements. There is tracking going on in pockets and on specific elements and dimensions, which is obviously very welcome, but there isn't even a sort of attempt at where that's been requested previously, in particular by committees in Westminster from the UK government to develop a more comprehensive system for tracking divergence and alignment, and the response has been no.
We do have those institutions set up by the Safeguarding the Union deal, and the commitments in that, so the British government's commitment to liaise more closely with Northern Ireland ministers and departments in the development of UK legislation, and the new government has repeated that as well. Now, what that looks like in practice is still yet to be seen, and those bodies such as the East West Council or Intertrade UK, how they actually function, can they liaise with Intertrade Ireland, for example? All of those questions still need to be worked out, and it doesn't address the challenge that Lisa identifies in those multi-level, multi-dimensional capacities for divergence. But it's fair to say the problem is acknowledged at least, and the Safeguarding the Union deal does in some way attempt to address that in creating these new bodies.
It seems as though if we look back at the last number of years, as problems have been identified, new structures and processes have been at least promised, if not necessarily implemented. If they are all implemented, then we could have a governance structure which does begin to address so many of the concerns, does actually effectively monitor, does provide voice. But we're still, I think, at the very early stages of this. I think, though, what's important to note is we're discussing here now a situation where there seems to be broad agreement between the UK and the EU about what needs to be done, and there's a professed desire to actually implement a lot of it. This contrasts with the situation 2 years ago where we got a huge amount of contestation and no real clarity. It's a different context for the implementation of these arrangements. That doesn't necessarily mean to say that there's not going to be big issues coming up and that there's going to be problems and difficulties there, particularly given we've got a new commission, new legislative programme which will be coming once the new commission's in place, and that will have implications for various aspects of the Protocol Windsor framework and what it means for what a law applies here. Okay. Joe, question.
Thank you very much for everything so far. I think my question is to you, David. I think if we end up, assuming we end up with an independent review, could you tell us a bit more about like what that then means? Are the UK or the EU under any obligation to listen to it, to act upon it? Because it seems to me the politics at the moment is that the EU position is you have to implement fully what we agreed 2 years ago. And the UK government seemed to have accepted that, and they're just going in a straight line to fully implement it. So what even is the point of the independent review if everybody already has their mind made up that the Windsor framework simply has to be implemented in full before anything further can be opened up for discussion?
A number of points there. I think first thing to acknowledge is that the review is a unilateral UK government commitment. It is not a review which is mandated by the UK and the EU, and therefore whatever comes out of that review, yes, the UK government is committed to bring it to the attention of the EU and into the joint committee. There's no obligation on the part of the EU to do anything with the review. Okay. Now, that said, the review will probably raise a whole host of issues around some of the complexities of the Protocol Windsor framework, the way it's being received, and the UK is keen to find ways through that review for arrangements which may, in due course, receive cross-community support. The EU is, I think, going to be effectively politically obliged to listen to what those concerns are. And I think in the spirit of the way in which some of the governance arrangements have been adapted over time to create mechanisms whereby stakeholders in Northern Ireland have been able to feed into some of the Commission thinking, it will probably give some acknowledgement to them. But I don't think it's going to come back and say, okay, we will actually take up these recommendations, but they will inform the discussion which takes place. Now, what I'd go back to an earlier point is the context in which you will actually begin be implementing the Windsor framework and addressing the concerns may shift significantly if you get that substance to the UK-EU reset, and we get things like regulatory alignment for the UK with the EU, because the range of problems and issues becomes slightly smaller here. But going back to the initial point, yeah, this is an internal UK review. Okay. Any other questions or comments? No? Okay, I think we've exhausted the questions online. I think just falls me to say thanks very much for everybody for coming along. For those of you attending online, if Lisa could just move one slide on, just going to do a little bit of advertising here. If you're interested in Article 2, Billy's running a event on the 29th of November looking at Article Windsor framework, and we're tentatively scheduling something for around about mid-December, where we might look at the outcome of the democratic consent vote and ask the question, where next for the Windsor framework in the light of whatever the MLAs decide, assuming they do vote. Okay. So anyway, thanks ever so much for coming along, for tuning in. Do look up the explainers that we've got about the democratic consent vote. We'll circulate those to people who've registered. And yes, look forward to seeing you again at some point in the future. Thanks very much.
Thank you.